Welcome, everyone, to meeting number 32 of the Standing Committee on Access to Information, Privacy, and Ethics. Pursuant to the Standing Order 1083H and the motion adopted by the committee on Tuesday, July 26, 2022, the committee is meeting to study device investigation tools used by the Royal Canadian Mounted Police. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23, 2022. So I welcome everyone to this committee, and I'm going to begin by I've just sort of discovered, I guess, this morning that we had in the notice we have two witnesses for this, which I am going to run in two separate panels. These are the witnesses that were contained in the motion that we adopted, and we will have, and then this afternoon, in our meeting this afternoon, we will have together in one panel each of all three of the witnesses that were provided by parties. So we'll begin for the first hour with Mr. Therrien, and then proceed in the second hour with Ms. Polsky. So with that, I welcome former Commissioner Therrien, no stranger to our committee. We've had many committee meetings together, so I welcome him back and invite him to begin this first panel with his opening statement. Go ahead, Mr. Therrien, you have up to 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. I'm very pleased to be here today. Thank you very much for having invited me to give testimony for your important study following the publication the 22nd of June on the government's response to a question by MP Van Ton regarding surveillance of mobile devices. In its response, the RCMP revealed that they had put together with investigative tools an investigation into mobile phones and other electronic devices of Canadians with judicial authorization pursuant to the Criminal Code.
Beyond what was reported by the RCMP in response to Mr. Van Ponta, my remarks will therefore focus on the content of the applicable law. I note that the RCMP reiterated yesterday that it does not use what it calls audits without judicial authorization, as this would be an offense under the Criminal Code. There is no doubt that the covert collection by the state of personal and other information residing on the digital devices of Canadians is an extremely intrusive practice. However, such level of intrusiveness can still be lawful and consistent with privacy principles if the collection of information is authorized by law and is necessary and proportional to the achievement of compelling government objectives. The RCMP says that its use of on-device investigative tools always follows judicial authorization pursuant to the Criminal Code. These provisions include several privacy safeguards. They can be invoked only for serious crimes. They require judicial authorization, often on a high standard of reasonable grounds to believe that a crime has been or will be committed, and that evidence related to the crime will be found on the device to be searched. Judges can subject the collection of information to terms and conditions, including conditions designed to limit the invasion of privacy.
These provisions seem reasonable. At least they're a good starting point for the privacy protection in the case of criminal investigations where there are overriding reasons for the state to use these powers and to go ahead with these actions with judicial authorities. Are these perfectible? It's possible, and the government seems to be open to it. To come to the conclusion that we need legislative change, we would first need to know how the current provisions have been applied and to prove if there's any concern. You have asked the RCMP questions with respect to that, with respect to the warrants that they have. Your study is looking at the conditions that will give Canadians the trust that their rights are being protected when there's intrusive methods that are being used by police. The existence of a framework, a rigorous framework and independence are at the heart of this question. The balance between transparency and protection of police methods are also at issue. So I will be very pleased to speak to you about these themes, answering your questions. Finally, the RCMP justifies the use of device investigation tools and other intrusive methods to counter difficulties they have with respect to encryption of data. Use of these methods needs, on a case-by-case basis, to have judicial authorization, and protection offered by encryption of data is not necessarily compromised, and so that seems to be acceptable. I would like to have you look at the publication by the Commissariat on the 5th of December 2016 within a government consultation on the national security issue. So I'd be very pleased to answer your questions. Thank you.
Mr. Therrien, and just before I go to the first speaker, I also, just as a housekeeping or just information for committee members, we do have not only potentially motions to deal with that may be moved, but we also are going to need to give some instructions to the analysts, and I am going to propose that we do that at the end of the second panel. If we have okay, I'm told by the clerk we will have a few minutes at the end of the second panel to deal with those items of committee business, so that's my intention. So with that, the first round of questions, we'll begin with Mr. Bazan for up to 6 minutes.
Thank you, Mr. Chair, and I want to thank you, Mr. Therrien, for joining us today. What years did you serve as the Privacy Commissioner of Canada?
Between 2014 and 2022.
So were you surprised yesterday during the testimony by the RCMP and Minister Medicino that the on-device investigative tool for hacking into our cell phones has predated your time as Privacy Commissioner, and they never once consulted you or asked about the privacy impact of using this on our devices?
I was surprised by the tool itself and how intrusive it is, and that it was used for so long. Certainly, there have been many discussions over the years, and as the RCMP said yesterday, probably since the early 2000s, on the lawful access issue, and both in my term as commissioner and when I was at the Department of Justice, I was following and part of these discussions. But the use of this particular tool to go around encryption, yes, was a surprise.
So, when you look at their, I guess, intentional, non-disclosure of using this technology, if you'd known about it sooner, would there have been recommendations made on how it should be used to protect the privacy of Canadians, coming from the the Office of the Privacy Commissioner, and would you had known, would you have been more, I guess, condemning of the RCMP for the use of this technology, or public safety for that matter, for not providing the regulatory tools to ensure the protection of the privacy of Canadians?
It's a complicated question. I would say, as Commissioner Dufresne said yesterday, that as he will, I would have looked at the conditions under which this tool would be used, the detailed conditions under which this tool would be used, to see whether there are any recommendations to be made on how it would be used beyond the four corners of the law, which is a good start again. Part 6 of the Criminal Code is a good start. It sets privacy safeguards. It sets high thresholds for judicial authorization. It has judicial authorization, so this is not as though the RCMP can use this tool without oversight by an independent body. But even with all of these good safeguards, I would have, and I understand Mr. Dufresne will, look at the sum total of the conditions under which the tool is used to see whether any further recommendations could be made on how to use it in a way that protects privacy.
But as you know, somebody with a great deal of experience on legal matters and the workings of government as it provides advice on things like justice and protecting the rights of individuals, that under Section 6 of the Criminal Code, there is different types of warrants, whether it's a wiretap, whether it's video surveillance. There's general warrants, which are more broad sweeping. Do we need to have, as a recommendation coming to this committee, a new type of warrant for the use of on-device investigative technology?
You asked yesterday whether judges who receive requests for judicial authorization have the technical, they certainly have the legal expertise, do they have the technical expertise to make best decisions? I'm assuming, I heard yesterday in testimony from the government, I think from the minister, certainly from the RCMP, that judges of superior courts have the expertise. So there must be some training given to judges. Should there be special kinds of warrants would depend on whether the current regime, as applied by judges with the expertise, legal and technical, that they have, is it sufficient to protect privacy? It may well be. I don't know.
So yesterday we were talking about the order paper question that came back, and in the order paper question it actually said that the RCMP had consulted with you as the Privacy Commissioner, or with the Office of the Privacy Commissioner, about the use of ODIT, which we now know never happened. But how did you interpret that response in the OPQ versus their actual testimony?
That the comment that we were consulted most likely related to some other related initiative, but not the use of this particular technology.
So as we look at these zero-click, spyware like Pegasus, and now we're finding out there's other companies out there.
Mr. Bazan, you really are out of time. Just wind it up quickly if you can.
Thank you.
But otherwise, we'll
Sure,
we'll
that
have to
was
go.
6 minutes?
Yeah, yes. Well, you started asking a question at 5:55, so we're going to have to go on to Ms. Hefner for up to 6 minutes.
Thank you, Chair, and thank you to Mr. Tarian for being with us again today. You mentioned during your opening statement that you understand that even technology as intrusive as an audit can be lawful in some circumstances. It can be necessary for law enforcement to have that ability to be that intrusive. Can you go into more detail about what sorts of situations might require police to have a tool like this?
I think what's at play is the balancing of privacy and other public interests. There is no question that this particular tool is extremely intrusive. It's more intrusive than traditional wiretap tools. It does not just record communications on the phone between person A and B. It sits on the phone, on the digital device of the individual, And the state, the police, has access to everything on that phone. So it is extremely intrusive. When you look at the balancing, therefore, there needs to be an extremely compelling public interest to justify the state being able to have that kind of information and use these tools. The criminal code sets out a limited list of offenses, serious offenses, where the police, with judicial authorization, is able to use the technology in question, things like murder, terrorism, drug trafficking, and the like. So I think, by and large, the list of offenses in question does fit a definition of compelling state imperatives.
And so, given that technology has advanced so much and that criminal organizations are very easily able to overcome traditional types of wiretapping, I'm wondering why you were surprised to know that police had sort of advanced their ability to investigate in the current technological age.
My surprise did not relate to the fact that the police has technologies to intercept communications in the context of investigations. But traditionally, these tools were somewhat limited. Wiretaps, again, intercept a specific communication. It is the intrusiveness of the tool that surprised me, not the fact that the state would use technology in the context of investigations.
Okay, so it's not, I mean, what we heard from police yesterday is that the communications these days are encrypted, either before they leave the device or when they come in. And so this is a technology they would use to overcome that encryption.
I accept that. I accept that encryption, although it has many, many benefits for society, protecting the privacy of communications of ordinary Canadians, commercial transactions and the like, can pose serious challenges for law enforcement. I accept that. And I, as I said in my opening statement, I think that to have technology to address the challenges of encryption with judicial authorization on a case-by-case basis that does not impede others from benefiting from encryption, I think that's acceptable. I'll say that part of my surprise was that there has been an ongoing debate, public debate, in the context of lawful access about this specific issue. To what extent can the police use means to overcome challenges of encryption? And it never came about in public debate that audits were used to that effect. So I'm not saying that it is unacceptable for audits to be used, but it was surprising that in the context of many, many debates in the public about the challenges of encryption, that when I was privacy commissioner, I was not told that a tool was used to overcome encryption.
Yeah. Is there any evidence or any indication that the RCMP has used this tool beyond the scope of what's allowed in the criminal code? Any indication of mass surveillance or anything like that?
I don't have that, and I know that the RCMP said yesterday it's not a question of just believing them. They told you yesterday that it would be a crime for them to use the tool without judicial authorization, and that they do not do that. I accept that.
Okay, thanks very much. I think I'm pretty much out of time, Chair, so thanks. I'll cede the floor.
All right, then we'll go to Monsieur Villemure.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Mr. Terrien, for coming to see us. It's always appreciated. Yesterday, the Commissioner said he was surprised to learn the facts, and you said you yourself were surprised. So we're here in a debate where we want to be able to preserve the trust of Canadians with respect to the institution. And we can see that the OPC is an institution where this is important. The RCMP told us that they had consulted with, and it was said that you were consulted. So it would seem that the RCMP is consulting you maybe on more banal issues or ordinary issues. They say they consult, but not for more important things. Would that be correct? Well, that's at the heart of your study, that question. And maybe it's more complicated than what it appears to be. Yesterday, there was question of modifying the legislation to allow evaluations on privacy, and I think that that is a good idea. Right now, this obligation is based on policy standards of the Treasury Board, and so there's a certain fuzziness, if you will, as to when such evaluations need to happen and when the Commissioner needs to be consulted. So to come back a little bit, I would like to repeat that when we look at the beforehand conditions with respect to trust, we have to have high judicial standards and independent surveillance. Part 6 of the Criminal Code gives you all of that. So it's not as though there's an absence of rules. We do have rules. But can the rules be improved? Probably. And yesterday it was question of looking at improvement, possible improvement, to indicate that the federal institutions or the RCMP have to consult the Privacy Commissioner, that there was a legal obligation, there should be a legal obligation to do so. That's a good idea. And I would add that if you do recommend to make it a judicial obligation, I would like to encourage you to give precise conditions where such evaluations need to be done. The standard of the Treasury Board says that there should be an evaluation done when there is a program or an activity, a new program activity, or that has been significantly modified that will affect privacy. And the RCMP told you yesterday that there was nothing really new to the fact that this particular technology was being used. So we don't want to concentrate on the technology, but you want to look at how is privacy affected. When I heard that from the RCMC, I wasn't personally in agreement with it, but I don't think it is unreasonable as a position. So I think, if you'll allow me, I think you have the responsibility to say, to decide when it's a judicial obligation to do an evaluation, when such evaluations need to be done, and to what objective. Essentially, that will give you a proactive assurance that the legislation is being respected, so that there's not simply an inquiry afterwards, but beforehand, that it is ensured that the legislation is being respected, and to be able to recognize privacy, as Mr. Dufresne said, that it would be a fundamental right. Yes, absolutely. Part 6 of the legislation, when does that date? From within the Criminal Code? For the Act on Privacy Protection, that is from the 1980s. So I think that it might be a good idea to have a new look at that. Yes, of course, you're right. Yesterday we heard a lot about Part 6. And you know, as I do, that you may have a legal situation, but at the same time it may not be ethical. So you say Part 6 is not complete. And I think that there would be a need to look into the situation in more depth. The impression that I got yesterday, that we just have to believe the RCMP, that really was the position that we were presented with. So should we really just have to believe them, or how can we really make sure that the people have the trust? I think that we have to look at a situation of Clearview here. When it's a question of facial recognition with Clearview, we had a legal framework that was very imperfect, almost non-existent, if you will. And there was no control with respect to any kind of independent authority. With Part 6, you do have both a legal framework with standards, and you have independence of the courts, the tribunals. So once again, is this perfect, and can it be improved? Well, yes, of course it can be improved. So it's not as if we don't have a good starting position. And because of that good starting position, I think that the public should still have trust that the RCMP is not going to commit a crime. That's what they told us yesterday, by using a tool without having the judicial authorization. But there still is the question that there are improvements that can be brought forward, and that can be done proactively with respect to evaluations based on how that affects privacy. Thank you very much.
Up to 6 minutes. Mr. Green.
Thank you. And I'd like to continue on getting to the heart of the matter for me, which is about strengthening legal frameworks. We heard from the Privacy Commissioner earlier in testimony the suggestion that privacy impact assessments should be part of the process. We heard from the Deputy Commissioner, or at least in the documents that we had received, that they have a process for onboarding new technology. So given that, your past experience in this, and understanding that much of our work as an ethics committee has been chasing situations after the fact in a very reactionary way, what points of legal framework would you recommend to this committee to help close the gap that clearly exists with what is legal and ethical, and I think what is technological in terms of the rate of advancement of the technology versus the existing legislation?
If we start with the potential amendment that would make it a legal requirement as opposed to simply a policy for departments and institutions, including the RCMP, to proceed with privacy impact assessments, it's a good start. I'll just say on this point, and Commissioner Dufresne spoke about what is the role of the OPC here. I just suggested to Mr. Villemur that perhaps you want to make recommendations not only on creating a legal requirement, but on having certain definition of what are these PIAs for. I would encourage you to consider what is the role of the OPC, what is the role of the courts. I don't think the OPC should duplicate the role that the courts play under Part 6 of the Criminal Code. I think the OPC's added value to the courts would be to look proactively at a program level, not at an individual case level,
Right.
the conditions under which the tool would be used, and make recommendations to that effect.
And I would tend to agree, and we heard as well about, with the Privacy Act coming up, the distinction of language being included in the preamble versus the actual legal frameworks to perhaps provide guardrails. In your experience, both with the Department of Justice and in the OPC, what recommendations would you provide in the upcoming Privacy Act that would be part of the legal framework that would provide, not just for law enforcement, but more broadly for the protection of this type of use against citizens here in Canada?
I think a preamble is a good idea. You said yesterday that you would want clear legal standards, such as the requirement to proceed with a PIA. I agree. But a preamble helps set for everyone, including government institutions, how do we look at privacy when a privacy impact assessment is made. So for a preamble to say privacy is a fundamental right essential for the preservation of the dignity of individuals, then when the RCMP or the health department or whatever institution proceeds with a PIA, they have that important message in mind. It's not a checkbox exercise.
But it was also determined that it's not legally binding. So how would we make legally binding the entrenchment of those rights as a fundamental right within the framework of the Privacy Act?
a preamble can still be used as an interpretive tool. So it's important to have a clear legal standard. Thou shalt proceed with a PIA. That's a
Right.
clear legal standard. But a preamble, although not executory on itself, is a very helpful interpretive tool to give life to the legal standard in question.
Okay, I'm going to go on a different line now. We've gone from the policy directives and hopefully the recommendations for legislation to what I believe to be an existing gap in oversight, which is what my colleagues have talked about, the police policing the police. In our sample warrant that was provided, it had a section on the interceptions on the device investigative tools that talked about how oral communications intercepted using an audit, the monitor who subsequently reviews the communication must cease reviewing the communication as soon as the monitor determines that no person in paragraph 3 is a party to the communication. So essentially we have this situation set up where this is placed on a device, it's being monitored, and we're supposed to take their word for it without what was described by the RCMP. They have no processes in place for auditing or performance evaluation of the sort. And my concern is that left unchecked without explicit guardrails as to when and how this can be used, the comprehensive nature of the capture of data seems to me to be susceptible to unlawful search and seizure of subjects and materials outside of the purview of the warrant. Would you have any comment on that? In terms of ways we might be able to provide oversight?
You might be partially surprised by my answer. So I don't think the RCMP is a rogue institution. And currently they say, and I accept, that they use audits only with judicial authorization. And judicial authorization comes with terms and conditions. I do not start from the premise that the RCMP wishes to disrespect these terms and conditions, and it may actually be a crime to disrespect the terms and conditions in question, because the use of the tool is only lawful if consistent with the terms and conditions imposed by the court. That said, it might well be a good idea to have auditing processes to ensure that the police officer who has to perform the task in question does so.
I'm really loath to do so,
but
but I must interrupt because we're significantly over time with that answer. But maybe if you didn't complete your thought, we could incorporate that into a different response. But it is time to go to Mr. Williams for up to 5 minutes.
Thank you very much, Mr. Chair, and Mr. Therrien, thank you very much for joining us today. You were the Privacy Commissioner for 8 years, is that correct?
Yes, I was.
So in your words, why is the Privacy Commission an important part of the Canadian government?
The OPC plays a number of roles. One of them is to investigate complaints, which serves, as I said a few minutes ago, as a independent oversight to the government. So the government has to comply with the law. It is assisted by the Justice Department, whose duty is to ensure that the government acts in accordance with the law. But all of these processes are within the executive branch. The OPC, one of its roles is to provide confidence, trust to the population in having an independent look beyond the executive branch mechanisms to ensure that the law, and particularly privacy laws, are indeed being respected. It also has a proactive role. But,
and where I'm going with that, I think you mentioned that it's about trust, right? So instilling trust through Canadians that when we have government and institutions acting in many different ways, that you can trust those institutions. Would that be correct?
Yes.
We yesterday, and I think you heard it as well, we heard from the RCMP, we heard from the minister that judges are only giving warrants where needed, that this technology is safe, you can trust us. And in that, they were stating that, well, they didn't feel they needed to do these PIAs, these privacy impact assessments, and that we've seen that. In your opinion, how right is that? Can we just trust government intrusively, or can we just get rid of the Privacy Commission? But I guess, how true are the words that they're explaining?
With respect, I don't think that's an example of trust us when they say courts only give the authorizations after review, therefore this is lawful. You say trust us. The question of trust depends on two things again: a clear and rigorous legal framework, and two, independent oversight. The courts provide independent oversight. We have a good starting point with Part 6 of the Criminal Code. Can it be improved? Probably. The OPC certainly has particular expertise in privacy to bring to bear, and proceeding with privacy impact assessments is most likely a good idea in the circumstances. There is also the National Security and Intelligence Review Agency, NZIRA, which plays a role, which also is an independent oversight body. So you have at least three institutions, the courts, the OPC, and NZIRA, that are independent from the executive branch, in total providing a measure of trust. Your study is, I think, about, given the intrusiveness of this technology, should the safeguards be improved? And it may well be that the answer is yes.
And in that role, the RCMP had mentioned yesterday that, sometimes this technology is used in active investigations. So can you please explain, having been in the role for so long, how a PIA protects technology that perhaps may be used, and allowing the government to use it in such a way where you're doing an investigation or a PIA, and how are you protecting that technology being used in active investigations? What steps do you have, or what steps can you recommend that be implemented to do so?
I think that speaks to the fact that there are many players, and each should play its role without duplicating the role of others. So the courts have an important role, but the courts are bound by the terms of Part 6 of the Criminal Code. The Office of the Privacy Commissioner looks at privacy more broadly under its statute, and it can therefore provide additional assurance to the public that privacy writ larger than the Criminal Code will be respected when these tools are used. So each of these mechanisms adds a level of confidence. To put it differently, the fact that Part 6 exists does not mean that the OPC does not have a role. It does have a role.
Okay, thank you. And now for up to 5 minutes, Mr. Hardy.
Thank you very much, Mr. Chair and Mr. Therrien. Fascinating topic, and I'm happy to sit in for my colleague Greg Fergus today. Judicial authorization is required. Is it required for more than just the incidents and the use of technology that we're talking about here? Are there other areas of investigation where judicial authorization is also required?
Well, generally under the Criminal Code, if there's an invasion of privacy through the use of investigative techniques, wiretaps would be a traditional method. Judicial authorization is also required. Search activities, obviously, which do affect privacy, require judicial authorization. So there are a number of manifestations of invasions of privacy that require judicial authorization.
Now, are you aware when judicial authorizations are provided? Are you given a heads up that there's activity going on?
No. I think on the basis that the courts provide independent oversight, and it's a mechanism that works on its own.
And are you confident that the privacy impacts that the courts assess when they're providing this authorization, are they reasonably well in line with the terms and conditions that you oversee?
I'm confident that the courts apply the law correctly, and if there's an error, there are appellate mechanisms to ensure that the law is applied correctly. I think it goes back to Part 6 of the Criminal Code, which sets the standards for the courts, has a certain definition of privacy, and the Privacy Act has a broader definition of privacy. So the fact that I have confidence that the courts do their job correctly does not mean that the OPC applying a slightly different definition does not have a role as well.
Now, notwithstanding confidence you may have in the courts, is there an auditing mechanism that you would be involved in to go back over the authorizations that the courts have provided to see if in fact everything is perfectly synchronized?
I think my answer to that would be that the role of the OPC might be to look into how the authorization process works in individual cases, not with a view to revisiting what the courts have done, that would be inappropriate, but with a view to determining whether the legislation is sufficient to protect privacy, the privacy of Canadians.
Now, we've been focused on the activities of the RCMP. Do similar provisions exist for CSIS?
There are different provisions for CSIS and for the CSE, the security establishment, for the interception of communications. Do these institutions use audit-like technology? I don't know. It's quite possible, but there are certainly laws governing the use of technology for the interception of communications by CSIS and the CSE.
Now, in the case of Jeffrey Delisle, the Navy officer that was ultimately convicted of espionage, we received a lot of information through the FBI. And I don't know that we could be confident that the FBI would follow the same rules with the use of technology that we would. Perhaps there is, but would there be any challenges, especially in the courts, of the admissibility of information that was collected and passed on by another security agency outside of Canada?
That's a difficult question to answer in the abstract. I believe Mr. Delisle was convicted, and therefore the court in question certainly had to be confident of the admissibility of the evidence against the accused. So again, there's important judicial oversight. I would leave it at that.
Would you, in possession of more information about what's going on when judicial authorizations are provided and what's actually taking place, why it was provided, et cetera, if you are in possession of that information, especially during an ongoing investigation, would you be compromised in terms of your obligations to Parliament to report and obviously be accountable for the application of the law?
I'm really sorry. I was slow there on the hook, Mr. Hardy. You began that question when your time was already up. So I don't know if Mr. Therrien, if you have
I don't think it is
brief answer, or again we'll have to.
I don't
come
think
back
it is the role of the OPC to second-guess the courts on individual cases, particularly on an active investigation. Again, the type of review that the OPC should be doing would be at the programmatic level, not at the individual case level, and certainly not while an investigation is occurring.
Okay, thank you. And now for 2.5 minutes, Monsieur Villemure.
Merci, Monsieur le Président. Dans les 2 minutes et demie que Monsieur...
Thank you, Mr. Chair. In the 2.5 minutes, I have two questions. Yesterday, an RCMP officer said something that I was wondering about. It was the use or potential surveillance by foreign companies on Canadian citizens. As a privacy commission, were you aware of any such practices? I didn't have any proof, but I did have some question, some doubt as to whether, a reasonable doubt as to whether or not it was occurring. Right now, are there any provisions that would stop any foreign powers to use surveillance in Canada? I think it's a question of national security and measures taken by national security agencies to stop any kind of illegal activity. Thank you. When the RCMP were told that the technology is intrusive, and yesterday the police officer said we always have a certain intrusion in privacy, but would there not be too much information? And is that information, is it really saved in a secure fashion? If the Desjardins situation, for example, there's a lot of information there, a lot of data. Well, it's true that there have always been methods to intercept communications, but with this tool, here we're moving into a whole different word with respect to the intrusivity of it. And despite what the RCMP said, I do not agree that the use of this particular tool, given how extremely intrusive it is, I think that definitely should have been evaluated in terms of the impact, privacy impact assessment. Yes, have I answered your question? Yes, you have. And so there could be less intrusive tools that might be able to do the same job. Do you have an opinion on that? Well, once again, it's a question of the role of the commission as a privacy commission as well as the courts. So with the criminal code, the court has to be convinced that there's no other means in the particular case to be able to achieve the objective, which is to collect evidence. And so there are already provisions that do make sure that the courts look at that.
And for 2.5 minutes.
Thank you. Given the commentary on the intrusive nature of this, the expansive nature of this type of technology, do you believe, or could you comment briefly, that the use of this technology by law enforcement has the potential to violate others' Charter of Rights and Freedoms?
Yes.
Okay. Are you familiar with some of the work that has happened in Europe on the investigation that happened around Pegasus NSO, and in particular in 2018, the Council of Europe, they adopted a protocol amending the Convention for the Protection of Individuals with regards to automatic processing and personal data. And basically, the principles underpin the rights guaranteed by the European Convention on Human Rights and establish new principles, including the concept of privacy by design. Do you believe that the principle of privacy by design should be a standard practice for any new technology that law enforcement agencies would like to use?
Absolutely.
Could you maybe perhaps take a little bit of time and expand on, in your opinion, define for people who might not know what privacy by design looks like and how it might be applied in this regard?
I've referred frequently during the last few minutes to court oversight. Court oversight, ex post facto oversight, whether by the courts or the OPC, is necessary. But it is far preferable for privacy to be baked in to processes that lead to the use of particularly intrusive technology. So the benefit of privacy by design or privacy impact assessment is essentially to ensure that the population can be assured that it's not only after the fact that a violation will be found, but that violations will be reduced greatly in number because the right processes have been put in place.
And would you agree that that would also include the principles of transparency and accountability?
Yes.
And we do know that, in fact, the RCMP in the past, particularly when it used Stingray, the ICMI technologies for the mass surveillance, they weren't actually forthcoming in their use. And in fact, it led to particular cases being thrown out of court. And so I just wanted to take this moment to underscore those principles. We talked about preamble versus legal frameworks, but transparency, accountability, and privacy by design ought to be baked into all processes of law enforcement.
Okay,
Yes,
thank
and
you. I don't think that was a question, and in any event, there
Well,
would be no
if
time
he's
for an
going to
answer.
agree to it, then it goes on the record and becomes part
Okay,
of the answer.
I'll allow him to
I
agree.
agree,
if
but
that's,
again,
if he will.
encourage you to give not very prescriptive definitions to these concepts,
okay,
but some general definitions.
Thanks. We will go now to
I can't provide that.
to Mr. Couric, and then we will finish with this witness with 5 minutes from Ms. Khalid. So go ahead, Mr. Mr. Couric.
Thank you very much, Mr. Chair, and thank you, Mr. Terry, and it's good to have you back before the Ethics Committee. Trying to get into a little bit more details as to what has been a interesting discussion. In particular, we see the responses that the minister gave yesterday, that he refused to disclose whether or not, and in a roundabout way, he did acknowledge that when other agencies do in fact use audits. So in a sense, he indirectly admitted that this type of technology is used by other agencies under the Minister of Public Safety's purview. If you had a chance to listen to his testimony yesterday, are you concerned about the lack of forthcomingness that the minister displayed before this committee yesterday?
I would again encourage you to clarify the law. If you want more transparency, make it a legal requirement and define the concept. Speaking about the RCMP, for instance, the RCMP's premise, and perhaps that was behind the minister's answer yesterday, is to try to be transparent, but to protect its methods of operation so that criminals do not know how they function, and of course investigations would be impeded. So this question of protecting methods of operation is always in the minds of police and government officials answering questions like this. I heard yesterday something that looked like a standard to me, which you might wish to consider, which would be that the government and the police would have an obligation of transparency, subject only to what is necessary to protect police methods and the integrity of investigations. In other words, the standard would be transparency. The exception would be limited only to what is necessary. And perhaps if that was clearer, not perhaps, it's clear to me. I've had many occasions, I'm not speaking about the minister, I'm talking about conversations over the years with law enforcement and national security. So it's not their starting point to say things that might impede their investigations. Sometimes they're overly cautious in assessing the balance between transparency and the protection of methods. If the law was clearer that transparency is the rule, and only when necessary to protect police methods is it acceptable not to be transparent, there might be progress.
A question that I asked your successor yesterday, and I think it'd be valuable to have your response as well. Does the Office of the Privacy Commissioner, when you were commissioner, take steps to ensure that if questions about operational integrity or the status of an investigation were to be part of the conversation around whether or not the privacy of Canadians would be protected in terms of consultations with the Office of the Privacy Commissioner? Did your office, while you were commissioner, take steps to ensure that those things would be protected?
The OPC has employees who are security cleared, This was made clear to national security and law enforcement. The national security and law enforcement understand that. So yes, these steps were taken.
Okay, thank you. And in the time.
No, you're finished, Mr. Kirk. I'm sorry.
Okay.
But your time is up.
Thank you.
And now Ms. Khalid for the next 5 minutes.
Thank you very much, Chair, and through you, thank you, Monsieur Terrien, for your presence here today. I think I'll continue down the same line of questioning that my colleague, Mr. Keurig, started with respect to what is the role of ministers in providing that oversight and how much of a say they have. So yesterday, we heard some testimony that the use of technology that we're talking about dates back to 2012, which means that either Vic Toas or Stephen Blaney were the ministers at the time. Do you think that the RCMP consulted with those ministers, either Minister Toas or Minister Blaney, before deploying that technology?
Before deploying audits?
Yeah.
I don't know. I heard Minister Mendicino say that this would be an operational issue as opposed to a policy or a legislative issue. So it may be that the RCMP decided to deploy the tool as an operational matter without informing or seeking authorization from the minister of the day. I don't know.
Thank you. And as the previous Privacy Commissioner of Canada, did the RCMP ever consult you before deploying this technology at the request of ministers like Minister Toas or Minister Blaney? Did either minister request or approve a PIA, Privacy Impact Assessment? Did you ever receive such a PIA during that time?
The OPC did not. I did not know. The OPC did not know that the police was using this tool. So no, we were never consulted on this in the past.
And do you know if the RCMP has used any of the software developed by the AWZ group, of which former Prime Minister Stephen Harper is deeply involved with, such as CoreSight, their facial recognition software, or ViSight, their behavioral recognition software?
I have no knowledge about this.
And I mean, we are wandering into fresh territory here for conspiracy theorists at home to listen to this and come away with the idea that the RCMP is doing mass surveillance. Do you think that that's true? Is the RCMP conducting mass surveillance on Canadians?
I don't think so. They said that they only use audits with judicial authorization. I accept that. In the course of our investigation on facial recognition, are they using mass surveillance? Probably not, but they're certainly using intrusive tools without necessarily clear legal safeguards and independent oversight. So mass surveillance can take a number of forms, apparently not through audits, probably not at all, but I don't know.
Thank you. And I know that we've had conversations from other members speculating into the role of preambles and making them into legislation. How important is it, do you think, to preserve the discretion of RCMP officers as they're conducting work of security and protection of Canadians? And where's that balance of ensuring that privacy is protected with that oversight, which is very important? But do you believe that creating rigid rules and regulations around that privacy, which in these cases, these 32 cases that we're talking about, were only intruded in the privacy of those that were being investigated for some very, very serious offenses like terrorism, like murder, like trafficking. Do you think that discretion should be allowed to the courts, to RCMP officers in the role that they play? And where is that balance?
You started with your question with a reference to preambles, and then moved on to whether there should be prescriptive rules. My answer is that, of course, government officials, including the police, ultimately have a role to play under the law. and the law should not be overly prescriptive. But at the same time, I think it is your role as parliamentarians to provide good guidance, maybe not overly prescriptive guidance, but good substantive guidance to government officials on how to exercise their responsibilities, and to have in the preamble to the Privacy Act the idea that privacy is a fundamental right. I do not think is prescriptive, and I think would be good, sound, general guidance to give to the RCMP.
All right, thank you. And,
Thank you. Chair, if I may, I'm just wondering if it would be possible to have Monsieur Therrien stay a little bit longer for the second hour as well. And I know my colleagues have questions as well.
Well, I had planned to split this into two panels with the two individuals, but I think that it would be up to Mr. Therrien if he wishes to remain.
I'm happy to stay.
This wasn't how I had planned to do it. But
thank you very, very much.
Okay, go
I
ahead,
appreciate
Mr.
that
Green.
a lot.
I have a point of order, I guess, from Mr. Green.
Yeah,
Go
just
ahead.
to make sure that we're clear that the extension of Mr. Therrien still allows for resetting the clock on the rotation.
Yes, I had
We're
planned
not
to
melding these
ensure
together,
that
so
with
we
these
get
two
2 minute
separate
sessions.
witnesses
Thank
from
you.
our motion would each constitute its own panel for that purpose. So yes, but Mr. Therrien is welcome to stay, and members may ask him questions. But I understand that Ms. Polsky is already on and was audio tested. If she can turn on her camera, there we go, and then we'll go straight into it without. Yeah. Sorry. Oh, Mr. Villemeux has a point of order.
Oui, Monsieur le Président, je veux juste
Yes, Mr. Chair. I just wanted to ensure that to hear Madame Polsky, I worry that the opposition is trying to ensure that we can't hear her, but I do hope that we'll be able to ask all the questions we want of Madame Polsky.
We'll be able to ask whomever they wish,
fine.
and as I said, we will reset the rounds, and with that, I'd like to begin because I'd like to end this as close to 1 o'clock as we can, to then deal with a couple of items that need to be disposed of. So with that, I welcome Ms. Polsky to our committee and invite her to begin with opening remarks of up to 5 minutes.
Thank you, Mr. Chair, and good morning here in Calgary to you and members of the committee. Thank you for inviting me to appear before you today. In 1964, Ronald Reagan said that freedom is never more than one generation away from extinction. In 1992, our Supreme Court said that the very efficacy of electronic surveillance is such that it has the potential, if left unregulated, to annihilate any expectation that our communications will remain private. The Supreme Court also said that we have a right to know when the state intrudes on our privacy. The need for this study tells us that the court has been ignored. As we saw with Clearview AI, police sometimes sampled data-oriented policing tools with no procurement paper trail, tools they say are needed for public safety, to guard against perceived threats, or as Bill C-27 allows, to provide for societal benefits. Put another way, technology itself is morally neutral. How its use is justified makes all the difference, which is why it is so very important that this study is not hidden behind closed doors, shielded from full public view. We know that the Stasi secretly spied on its citizenry, but we don't expect democratic governments to spy on theirs. Yet it's now happening in Canada and around the world with journalists, executives, social activists, elected representatives whose views differ from the ruling party being spied on. Until recently, though, Dudley Do-Right and Sergeant Preston were what people thought of when they thought of the RCMP, defenders of justice and fair play in their relentless pursuit of lawbreakers, respecting the intent and the letter of the law, the Charter, and Canadians' privacy, not using an unreported surveillance program to spy on Canadians' social media accounts. Granted, spyware can help police do their work. More often, though, it's downloaded by the hundreds of thousands and used by human traffickers to control sex slaves, and in domestic conflicts, to terrorize partners. It's also part of a lucrative new sector that's made our privacy, our freedom, our democracy only a crisis or an election away from extinction. Because how can any MP or bureaucrat be certain that cabinet confidences, military strategies, election plans, that anything can be discussed privately when there's a very real chance that a hidden app is letting someone somewhere in the world listen, watch, and record your every text, email, photo, siphon your contacts, your passwords, silently turn on the microphone and camera to watch and listen to you and your surroundings undetected. As for the question of whether there's any social benefits in spyware, the answer is a perverse but resounding yes. It's the Ford Pinto of technology, a danger hidden to the public in general and to certain people in particular, with lots of socially beneficial spin-offs, jobs, commerce, and taxes. The global cyber crime industry generates more than $1.5 trillion US annually. The global cybersecurity industry is at $1.7 trillion. And in Canada, it accounts for $3.5 billion US right now. Pegasus is just the latest spyware to make the headlines, and it reminds us that spyware is a nonpartisan, equal opportunity endeavor, and that the post-9/11 tools to combat terrorism have made us all fair game to be targeted and our words used against us. Maybe they already have been. Disrupting the mercenary surveillance industry will require multi-partisan political will, a coordinated domestic and international effort, and a shift in approach to prevent the damage from being done in the first place by regulating the exploitation of privacy. Put the onus where it belongs. Spyware developers, producers, distributors, and investors, and the inherently faulty technology, and make the risk greater than the reward, because regulating internet content won't stop spyware or child predators, and laws banning hacking for hire companies and occasionally catching a criminal hasn't made a dent. Using spyware needs to be made unlawful except in specific, exceptional situations and for the shortest possible duration necessary to accomplish a specific investigatory goal, with its use approved in advance by a genuinely independent, knowledgeable, apolitical third party, so that Canadians can regain trust in government and the public sector and have reason to think of Mounties as Dudley Do-Right, not Snidely Whiplash.
All right. With that, thank you for your opening statement, and we go now to Mr. Bazan for up to 6 minutes.
Well, thank you, Mr. Chair, and I want to thank Ms. Pelosi for joining us today. How shocked were you as the President of the Privacy and Access Council of Canada to learn that yesterday under testimony the RCMP have been deploying on-device and investigative tools since before 2012?
Unfortunately, not at all.
So, as you know, this mobile hacking system that's been used on our devices has been banned. Well, Pegasus in particular has been banned from the United States. Are you advocating for this type of technology to be banned or to be used under more stringent guidelines by policing agencies and other organizations?
I think it's a broader problem than that, because it's not just a matter of banning the police use of a tool that can be used for legitimate purposes, whether by police or other law enforcement agencies. Problem is, though, that these things, these tools, however technically advanced they might be, each one of them, they're available commercially to anybody who has an internet connection and wants to download them. That is what is the problem, because otherwise we're all just working after the fact to try and catch whoever's using it. Our criminal code, as far as I'm aware, does not speak to somebody putting spyware on my phone or yours, a spouse, an intimate partner, a stranger. If they take the intimate photos and distribute them without my consent, that's addressed in the criminal code, but not spyware itself. Nobody's talking about preventing the spyware from being used in the first place, and nobody's talking about how the spyware is able to take advantage of the shortcomings, the deficiencies in so many software programs. Google just introduced 27 fixes, including critical fixes, last week in one day. And they and others keep introducing fixes for faulty software. Require that software be tested properly to minimize the opportunity for spyware to be able to take advantage of, right now, the built-in deficiencies.
So, knowing that some of this is available commercially, and I learned just in the last 24 hours, we talked about Pegasus, but now there's also Paragon, Kangaroo, Cognite software. There's the possibility that this has been onboarded onto drones. Which examples or which software platforms are you aware of that have been used here in Canada?
I don't know specifically. I have spoken with colleagues who have been researching this area, and I've been assured that there's several, but it's not spoken about. Obfuscation is a wonderful thing. If you describe a tool as a digital investigation tool, it doesn't say that it's spyware. It gives it the air of legitimacy. I don't know in particular which is being used and which is not.
Do you believe that Minister Mendicino yesterday was obfuscating? You think that after his testimony that he restored trust in our institutions on whether or not they are being surveilled or they are surveilling Canadians?
I found his responses interesting, particularly when he repeatedly assured us that these software tools are only used within the limits of the law, although I believe it was perhaps it was someone else who said that there are provisions in national security law that allow for the exigent use of these without judicial authorization. So even that's within the limits of the law.
And so, yesterday there was the admission that the RCMP have been using ODIT since 2012 and before, but he kind of skirted around the issue on whether or not other government agencies are using it. So do you believe that Canadians have the right to know whether CSIS, CSE, CBSA, Department of National Defence are using these tools as well?
I think Canadians do have a right to know, and it is possible to reveal the use of these tools without compromising police investigations.
So how dangerous is it to our civil liberties and our ability to appropriately legislate the use of these tools when we have a government that has not admitted the basic facts of who's doing what with ODIT?
Well, I do recall our Prime Minister several years ago said that Canadians deserve the most I'm paraphrasing, the most transparent, accountable government. And I agree, we do. But as a taxpayer, as a Canadian citizen, I'm skeptical whether that's actually come to pass. And as a practitioner in access and privacy for many, many years, and knowing many people in the industry, including in our nation's capital, it seems the way the access laws were written are being used to create more of a shield than a view of what's going on.
10 seconds.
Well, I want to thank our witnesses for being with us today.
All right. Thank you, Mr. Bazan. And now Ms. Hefner.
Thank you, Chair. I would like to return to Mr. Therrien, if I could, and some of the conversations that we were having in the previous hour. There's been a lot of suggestions that judicial oversight isn't enough. And I think what I heard from you is that it's actually pretty good protection. It's not the only protection that we have to ensure that the RCMP fulfill their mandate and by the letter of the law. Because, for example, if they were to collect information through the use of this technology and took it to the court to use in prosecuting their suspects, and the court found that they didn't use it properly, then the evidence is no good. It's worthless to them. So it's no good for the RCMP to be using this technology outside the letter of the law. And I'm wondering if you agree with that, and if you can expand on that a little bit.
I think it's a fair characterization of what I said, that the privacy safeguards in Part 6 of the Criminal Code are good. They may well be perfectible, particularly given the highly invasive nature of audits.
I'm sorry, expand on that a little bit. What do you mean?
Yes, the protections of the criminal code are good. Are they ideal? Are they perfect? Are they perfectible? I leave that to you. I think certainly improvements are possible, but they are good. We have a good starting point.
Yeah. We also heard, as one of my colleagues brought up yesterday, that we may be more at risk in terms of MPs and our cell phones from outside actors and people outside the country who maybe aren't concerned with following the criminal code. Can you expand on your thoughts on that as well, and the level of risk in this country from outside of Canada?
Canadian law governs Canadian institutions, including the RCMP, and by and large, we have good rules. As we know, there are a number of countries around the world that are not democratic, do not care much for the rule of law, and it is entirely possible, likely, the RCMP seem to suggest it's a fact, that other states do intercept the communications of foreign nationals, including Canadians, for their own purposes. So it's according to the RCMP, it's a fact.
How does Canada compare to other countries when it comes to the valuing the right of privacy of its citizens?
Clearly, Canada is a country under the Charter, the rule of law, that overall has good standing in defending human rights. But at the same time, it was mentioned a few minutes ago that the public sector privacy law is 40 years old. The law was adopted when documents held by the government were held in writing in filing cabinets, and the information could not be obtained or disclosed as easily as it is in 2022. So overall, obviously, we are a country that respects the rule of law, but our laws, particularly privacy laws, are in dire need of improvements from a privacy perspective.
Thank you. And in the minute and a half or so I have left, maybe you could just go over some of your ideas, and I'm sure you've already brought them up today, but some of your ideas for improving our privacy laws to make sure that we are at the highest standard.
So I think Canada's laws, both for the public and the private sector, should recognize privacy as a fundamental human right. That's the starting point. It should ensure that the Office of the Privacy Commissioner, both for the public and the private sectors, have the authority to actually not just make recommendations, but to make orders to the private sector and the public sector when it sees violations of the law. And there should be financial sanctions, certainly in the private sector, to ensure that these laws are respected. I would say, because I think it's relevant to this particular study, and there was a reference a minute ago to the use of these intrusive technologies in the private sector, that in 2022, information is shared between the private and public sectors extensively, and it is important, at the very least, that the public sector and private sector laws be compatible, interoperable, and ideally would be adopted in one statute, because Data does not know frontiers between the public and the private sectors. And again, at the very least, the rules should be similar and interoperable as between the public and private sectors.
That's
Thank you.
very helpful.
And,
thank you.
Now, thank you. And now on to Monsieur Vermeulen pour 6 minutes.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chair. Madame Polsky, welcome. Thank you for being here. From the beginning, we've been saying we're talking about privacy protections. We're talking about trust. Several people have asked me, people in my writing have asked me, well, they say, well, I don't have anything to hide, so why do we need to bother? But I don't know that people really understand the level of intrusion we're talking about with spyware. Would you be able to explain to us so that we can ourselves explain it to those in our writing? What are they facing?
Saying that I don't have anything to hide. People have said that to me, and I've said, show me your bank statement. And they get weirded out by it. People do have things to hide, but it's more a matter of when I wish to share a particular bit of information about me that I should have a choice. For those who want to display their life online in the minutiae of their lives, that's their choice. But to paraphrase Senator Simons, governments aren't always benevolent. And I look to Hungary and to Poland, but Hungary in particular, which has changed in recent years to become rather authoritarian. And its data protection authority that you would expect has a role similar to our privacy commissioners, has ruled that the use of Pegasus against that country's journalists does not violate the law because there is a national security component. Things that are okay today can be changed on a whim these days and used against you, taken out of context. And that's nothing new. That's gone on for time immemorial. We need to have the choice and to have our information or information about us gathered, taken, assembled, assessed, analyzed by we don't know who, that we've never met, we've never given permission, and what are they going to do with it? We're looking at McCarthy hearings again. It's frightening, and I've been around a long time. There's not a lot that scares me. What's going on now is frightening, and that's what people need to realize. It's not just benevolent.
Mm-hmm. Est-ce que y aurait lieu peut-être d'avoir...
Should we have a public debate or education on privacy so people are better able to understand what they're faced with?
Oh, that would be wonderful. I mean, desktop computers have been around for almost a half century. And as far as I'm aware, there really is not yet any substantive education, whether for school children, whether at the youngest grades or even in university. They're taught to code perhaps, but not everybody needs to code. And knowing how to code doesn't mean you understand privacy, what privacy is, how it can be undermined, how to protect yourself from clicking the wrong thing and endangering your device, your enterprise, and perhaps in your case, the nation because of national security. I have spoken with a variety of members of the bench from across the country over the years, and one after the other have said, I don't know what this privacy stuff is. I'm at this conference to learn it, even though I'm adjudicating matters that are sensitive as to privacy. There has not been enough, and there needs to be a dedicated, mandatory education component embedded as a pan-Canadian strategy, if you will, so that the provinces and territories can have the encouragement to embed this as a mandatory part of the curriculum, starting at the youngest grades.
Croyez-vous que pour le moment...
Do you think that to better understand the situation, there should be a moratorium on the use of such devices, spyware, until we better understand it?
Well, it would be lovely, but we've seen moratoria declared on facial recognition in the past few years by various cities and states and countries, and now they are sliding back to saying, maybe it would be a better thing if we had it. that's a temporary measure. I think it's more important to get to the source of the problem, which is the faulty software that provides the opportunity for spyware and ransomware and other malware to be effective.
Merci beaucoup.
Thank you very much. Do I have any more time? Mr. Terrien, earlier you were talking about privacy and how it is now in different legislation to protect both on the private sector and also the public sector. Would it not be good to have one statute? I think it could be complex, of course, but so that we wouldn't have any kind of problems. It is the situation in some countries because data moves between public and private sectors, so that would be a good idea to have one statute. But I would add the fact that we have waited 40 years to modify in the public sector and 20 years in the private sector in terms of the risks. Putting of everything into one legislation today, it could mean the risk of delaying things for the private sector, and which does have legislation before the government. But in terms of the principle, both private and public sectors should be regulated in a similar fashion. The context is somewhat different sometimes. However, the legislations should have similar, if not identical, principles. Thank you.
Now, Mr. Green for up to 6 minutes.
Thank you very much. I'm sure you would note that the President of the Treasury Board is responsible for providing policies to ensure that there's, and is responsible for establishing policies and prescribing forms regarding the operation of the Privacy Act in the public sector, correct? So we know that they've had this mandate for quite some time. During your time as a privacy commissioner, could you comment on the rate at which ministries and agencies under the Privacy Act have proactively presented policies and measures for outcomes and accountability within their departmental plans and reporting back to public accounts or to your office that you felt kept pace with technology as it is today?
That's an excellent question. During my term, I would say that Treasury Board, as a matter of priority, because of limited resources probably, spent more time on access to information questions than privacy questions. Not that they were absent from the privacy landscape, but they certainly gave priority to access to information. There was an access to information bill presented, etc. The long and short of it is that there was not an absence of activity, but there was not a whole lot of activity.
So it's safe to say that even though in spirit, the policy of the Treasury Board directing all agencies to enact enhanced protections under the Privacy Act didn't necessarily result in proactive new policies that are in keeping with the pace of technology today. Is that safe to say?
Yes, although I will say that in the recent year or so, there have been interesting developments. So a policy on artificial intelligence, for instance. But over the term of my term, there was not a whole lot of activity. More progress recently.
And in the time of your term, how much of that activity in proactive improvement and self-reflection and auditing came from law enforcement and public security agencies with specificity around the RCMP? Was the RCMP leading the way in improving their processes around privacy?
No.
Okay.
If we look at facial recognition and the creation of what they call NTOPs, it was at our request. It was not proactive on their part.
Sure, and is it also safe to say that in some of your dealings, and I hope we could be candid here, that maybe they weren't always forthcoming with the information as necessary for you to be able to fulfill the duties of your work in a timely manner?
I think they function within the law as it is.
That is an important distinction because what's before us today isn't necessarily a positioning of the RCMP as being rogue or going outside the confines of law, but it's the gaps, I would argue. And in fact, Deputy Commissioner Larkin in his testimony suggested there was gaps in legislation. So would you also then agree that even though what is currently legal, and I think we've established is quite outdated, might not necessarily be ethical given the way in which technology has outpaced legislation?
Whether it's ethical or not, there are certainly improvements that are possible given the intrusiveness of the technology beyond Part 6 of the Criminal Code, yes.
And, you know, I think that there'd be a long debate on the ethics of it, but I would put to the committee that if we have technology that goes beyond the spirit of existing legislation, is known to be such, is then in some instances, whether it's Stingray or the Operation Wide Awake, which was a social media surveillance, or others, that if they're not proactively disclosing these things, then it doesn't give legislators the opportunity to keep up with it. And I think that's the spirit of what's before us here today. So I referenced the European Convention on Human Rights that established transparency, accountability, privacy by design, and data protective impact assessments. That's a relatively modern piece of legislation. In your mind, how does Canada compare to that?
We, by and large, have policies, not always respected, that have a similar spirit, but there are not legal requirements. And I think it would be extremely helpful to change these policy rules into laws so that the likelihood that they would actually be implemented would increase significantly.
I would agree. I would agree that in my position, having been on public services and procurement and public accounts, and now this committee, we have a government who's really great at writing good policy. They actually write some decent policy. The challenge is we never have the outcomes. We never have the measurables, and we never have the deliverables when it comes to taking something like the directives of the Treasury Board president and watching it actually be implemented in government. And so, you know, from that perspective, what I'm hearing today, and we can get into distinctions between whether or not it's prescriptive or non-prescriptive or whether or not it's preamble, I'm a firm believer that if we don't direct law enforcement to improve and increase their transparency and to provide clear measures of accountability and privacy by design, it won't happen. Would you agree with that? That
yes.
If we don't provide those guidelines, it just won't happen?
Yes, and further, I think it is possible to have these requirements at a sufficient level of generality but still meaningful without being overly prescriptive and preventing officials, whether by the police or others, from exercising judgment. But
thank you.
Thank you.
We'll go now to Mr. Williams for up to 5 minutes.
Thank you, Mr. Chair, and through you to Ms. Polsky. Nice to see you again. After the RCMP was caught using mobile device identifiers, or IMSI, in 2017, they said they wanted to start a public debate about police powers and privacy. That discussion was clearly never started. Do you agree with that statement?
I'm not aware that they did engage in that study.
Okay. Do you think that the balance between police powers and privacy should be changed, and what should it look like?
I think police need to recognize that they're not always going to be in uniform and that it affects them individually just as easily as you and I and anybody else. The police, I think, members of the law enforcement are like everybody else. They too lack the fundamental education about privacy, rights and responsibilities, legislation. They are law enforcement, and that's what they do. They see it from that perspective, as they ought to, but they need to be encouraged to see it from other perspectives.
What does Parliament need to do to properly regulate these types of uses of spyware by the RCMP, the CSIS, and CSE, for examples?
Well, first of all, I think if the spyware is regulated in the hands of RCMP and federal agencies, that doesn't address the municipal and the provincial law enforcement agencies. So it has to be all-encompassing. I think it's a matter of crafting laws, again, without the direct or indirect influence of industry, that put the liability firstly on the hardware and software companies and their executives who sell products that are full of vulnerabilities that allow spyware and ransomware and malware attacks, ban federal procurement or use, directly or indirectly, of spyware by legislation or regulation or order in council, with equivalent bans in each province and territory, and work with federal government, with foreign governments rather, to ban the sale, export, distribution, use, and the investment in commercial spyware. We already have international free trade agreements that have mandatory cross-border information sharing provisions and all sorts of other provisions. They need to include provisions where signatories agree to criminalize and prosecute the individuals and the organizations that create, test, market, fund, distribute spyware, and the executives and the investors. There's got to be penalties, because otherwise it's like policy, it's on the books. But if someone in another country can use these products against us, their own governments have to be involved in stopping it, because that's in that country, of course. It's out of the reach of us. So
to just add on to my colleague's statement, what good policy has actually been implemented in other countries that we should be implementing here in Canada?
One of the most important differences, I think, that a distinction that the GDPR in Europe brought to bear is that when a privacy impact assessment is conducted, when an organization has a data protection officer, which they must, their focus under the GDPR is the risk to the individual whose information is being collected, used, etc. It's not the risk to the organization. And in my experience, that is all too often how Canadian organizations look at it. First of all, if they have a preliminary PIA, because we're busy, we're a large organization, the few people who actually understand it are too busy to do a PIA for everybody. So they ship it back to the department and say, here, you do a PIA, a preliminary one. You tell me if you think we need to do a PIA. They don't know what they're looking at. So of course it's easy to say, nah, it doesn't affect personal information, so we don't need a PIA. And that's where it ends. That's a flawed system. And when they do a PIA, some of them are just so cursory. It talks about the benefits of a product or a new system or something, but it doesn't talk about the risk to the individual. It's as if their role is to protect the risk of the organization. That has to change.
So Mr. Chair, last question it'll yes or no, that's all it'll be.
You got 10 seconds.
Okay, to both witnesses, should skipping the PIA be an option at all?
No.
Thank you very much.
Well done. Now on to our next question. Will be Mr. Erskine Smith. Welcome back to Ethics.
Thanks, Pat. It's good to be back. Good to see you, and especially good to see you, Mr. Tarian. I have appreciated your advice and guidance over the years when I did sit on this committee. I want to start with what I took to be the RCMP's view around we can't disclose the vendor because of national security, and yet from a government procurement basis, it's quite concerning to me, because I see some of this technology, and I know RCMP has said they don't use Pegasus, but Pegasus, being an example, has been used to undermine human rights seriously around the world, attacking journalists and other human rights advocates. So as a matter of public interest, shouldn't we know who the vendor is so we can conduct some level of due diligence around government procurement?
That there be transparency in the procurement process is certainly a very good idea. It's necessary, actually. But on whether the name of a particular vendor should become public, I would go back to the general standard. There should be transparency as a rule, except if the protection of methods, if methods would become ineffective through transparency.
I think that's the right standard. It's hard to imagine how the name of a vendor would undermine national security, despite the protestations we heard yesterday. So I guess moving to the core issue, and we've talked about the the nature of the tool and just how expansive it is with respect to collecting data. But what I want to take a slightly different tack, Mr. Tarian, because what these tools tend to do and what makes them demonstrably different from other tools is they take advantage of and they exploit an existing vulnerability in the technology as it is. And so you have law enforcement that is exploiting a vulnerability, and that vulnerability affects all Canadians fundamentally because that vulnerability is on all devices. And so isn't there an argument that law enforcement should be identifying that vulnerability and then letting the vendor know, or sorry, not letting the vendor, letting the company know about the vulnerability such that it's fixed on all of our devices?
It's a daunting question. So yes, if government officials see a vulnerability in a system, they should notify the creator or the vendor of the system of the vulnerability. As a principle, generally applicable and implemented, yes. That said, encryption is a challenge to law enforcement. So I think I make a distinction between laws dictating the creation of backdoors and laws that authorize the police to circumvent encryption through existing vulnerabilities for a certain period, because that may be the only way to actually perform the investigation. I don't know, frankly, what is the best solution in this regard. I agree with you that there is an obligation to inform the vendor or the creator at some point. But how does the police, I see what is being done here as less problematic than laws creating backdoors, particularly where there's judicial oversight of the system.
Let's talk about that oversight in the remaining time that I've got. So I'm comforted that the RCMP has said that they've only used this technology via judicial oversight. Of course, it would have been nice if it was more proactive in their disclosure of the use of this. We now have a pattern, I think, when we look at Stingray's, Clearview AI, and now the spyware technology. And again, we don't know who the vendor is. But don't you think the Privacy Commissioner ought to be involved? When I look at the RCMP tell us 1 out of every 10 requests didn't receive internal approval. So 9 out of 10 requests did not receive internal approval. I don't know what that internal approval framework is, frankly. And I would think that if I were responsible for the RCMP, I would proactively engage with the Privacy Commissioner in establishing that internal framework. Would that make sense to you?
Yes. Absolutely. That's what we recommended for facial recognition, which led to the NTOP process. Yes, the OPC should be involved in ensuring that these processes are sound and robust.
Right, because then you have the internal approval framework in consultation with the OPC, and then you have the judicial framework on the back end. Thanks, Mr. Tarian. I appreciate your public service. Take care.
All right. Thank you, Mr. Erskine-Smith. And now, Monsieur Villemeux pour 2 minutes et demie.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Tarian, would you say that the RCMP has developed a culture of privacy? The RCMP has a culture for applying the law as it stands. It's true, as it was said, that the RCMP doesn't necessarily have a high level of expertise for privacy protection. In the last year of my mandate, I saw that there was a will to increase the knowledge of privacy protection at the RCMP. So things are moving ahead. Oh, that's good. Madame Polsky was talking about the PIA's Privacy Impact Assessment. So do you agree with what she said? Well, yes, that's why I would encourage you not only to have the legal obligation to have these PIAs, but also to dictate within the law the content and the objective. of these assessments, because as I've seen, sometimes the evaluations are simply mechanical, checking off the boxes. And that really doesn't serve any purpose. We need to ensure that programs and activities be designed with respect to privacy, and respecting privacy as a fundamental human right. That's what needs to be done. Thank you very much. Madame Polsky, in less than a minute, do you think that it's time to have a public debate on the subject so citizens can better understand the danger that we're speaking about here?
Absolutely. And I think Canadians need to be engaged to understand not only what's at stake nationally, but personally. So again, I go back to education, and it's mandatory, because otherwise they have no option, whether personally or in a corporate or government role, to take the word of a vendor or someone else without being able to have critical thought and ask the questions that need to be asked and know if they're getting legitimate answers.
Merci beaucoup.
Thank you very much.
Thank you. And now for 2.5 minutes, Mr. Green.
Thank you. I want to go back to the end of my last question, because I feel like Mr. Therrien was about to expand on his thoughts around how we can bridge the gap between the policy directives that are instituted under the purview of the President of the Treasury Board with the Privacy Act, to all and extended to all the boards and agencies, including law enforcement, to begin to build in this culture of the underlying value of privacy as an actual fundamental right.
I think the law is crucial here. We have in Canada policies that promote privacy, but sometimes, frankly, this is a little bit hollow. It's a checkbox exercise. For PIAs and privacy by design to be meaningful, to recognize privacy as a fundamental right, to ensure that there are adequate enforcement, including order making and fines, means that it is no longer possible for either the private or the public sector to speak the good word, but without actually delivering on privacy protection. So policies are good, but they need to be backed up by serious legal standards and independent oversight.
And this is something that we've been kind of circling around at this committee in such a short period of time, responding to the recent use of this particular technology within the RCMP. But I think, as you alluded to, it's not confined to that. I think it's safe to say that if the RCMP is using this technology, I would suggest we're likely to see it at the CSE and CSIS levels, although they have different constraints and requirements. But the one thing that we didn't touch on was the possibility of the government doing indirectly what it can't do directly. So would you just end by commenting on ways in which we might be able to ensure that our government isn't utilizing, even though it might be legal, I would suggest not ethical, unlawful information, unlawfully gained information from our foreign partners within the international security framework with Canadian agencies?
Just a very quick answer, if you can, because we're out of time.
I'll answer with regard to the private sector. In our investigation, in the OPC's investigation of facial recognition, we recommended that the law be clarified, that the government, the state, cannot do indirectly what it, through the use of the private sector, what it cannot do directly. I think that's a big part of the answer.
Right. Thank you. And for the final two rounds, we'll have Mr. Kirk for 5 and followed by Ms. Khalid.
Thank you very much. Mr. Therrien, are wiretap warrants automatically that are used by law enforcement under the criminal code automatically sealed?
I think they're generally sealed. You're going a little bit beyond my area of expertise here, but they're certainly generally sealed.
Okay, thank you very much. Ms. Polsky, there was some very interesting testimony today, so I'm going to ask you a series of questions. One, related to the letter that the commissioner of the RCMP had sent to this committee, refusing to disclose some information that this committee had asked for. Is that something that concerns you?
Very much. My view as a Canadian, a taxpayer, is that government, our law enforcement agencies, they are there to serve the public, not hide from it. It just doesn't come across as being deserving of trust, and trust has to be earned. And to just flatly refuse a parliamentary committee and say no, that was surprising. It makes me think: are they hiding something?
No, I appreciate that. So yesterday, when the minister was not forthcoming, when a number of us, including myself, asked questions related to the use of exemptions, national security exemptions, is it concerning to you that the minister responsible for these agencies would not be forthcoming as to whether or not exemptions were used to circumvent some of the judicial processes that are laid out in the criminal code?
Well, it certainly is concerning that there's a lack of clarity. It just seemed evasive.
So as there's questions about operational integrity and ensuring that investigations, the integrity of investigations is upheld. And the commissioner, both the current and the previous commissioner for privacy, has outlined how there are safeguards in place. Do you find it concerning that it seems like both on this issue but also previous areas that the RCMP has only responded to privacy concerns after either parliamentary or media outcry related to things like the use of ODIT, Clearview AI in terms of facial recognition, that sort of thing?
I think it's a problem that they are not collaborating with the Office of the Privacy Commissioner of Canada in advance, and it's only after they get caught with their hands in a cookie jar. I think they're doing themselves a disservice, they and every law enforcement agency across the country, a disservice when they are not forthcoming. It also puts them on the defensive rather than coming forward and saying, we need to use this type of tool. It doesn't give away any investigative information. It doesn't, being general like that doesn't undermine investigations. It doesn't reveal anything sensitive, but help educate the public as to why you need this particular type of tool. Don't wait to be put on the hot seat and then give non-answers like so many of them were yesterday.
Okay. Thank you very much. Mr. Chair, how much time do I have left?
You've got about a little over half a minute.
Okay. So when it comes to specific actions, Ms. Polsky, do you believe that it should be outlined in privacy legislation that there should be proactive disclosures as opposed to parliamentary committees or reporters having to chase down whether it's the RCMP or other entities of government to try and bring about a public understanding of some of these privacy concerns?
Yes, having it in law is necessary and is got to be clear, not open to interpretation by an organization that wants to use the law to its advantage, not for the sake of clarity. But I caution that saying, well, we have new legislation, Bill C-27, the Artificial Intelligence Data Act, that will protect it, but it doesn't, because any organization that is deputized, if you will, by CSE or CSIS, they can do it. They can do what the government can't.
Thank you, Ms. Polsky. We'll now finish this panel with Ms. Khalid. Go ahead for the final 5 minutes.
Thank you very much, Chair, and thank you again to the witnesses. Monsieur Terrien, if you don't mind, I'll continue with you. Now, we've heard the scope of this spyware and its use and its intrusive nature on not just Canadians, but people in general. The European Union has been involved in, for example, putting Pegasus, saying that it is violating rights. do you think that Canadians should be able to sell spyware like Pegasus to anyone at all? Like, for example, I know I had mentioned AWZ Group in my previous questioning. Should organizations like those be able to sell this extremely intrusive technology? Should the government be regulating not only the use of that within our country, but also the sale of that abroad?
Yes, there should be laws regulating the sale, import, export of these technologies. Should it be banned completely? We see in this study that there may be rare cases where the public interest would make the use of such technology by the state permissible. But definitely there should be laws around sales, import, and export. And by the way, I would say, while I can see compelling grounds for the government, for the state, for the police to exceptionally use this type of technology with judicial authorization, I cannot really see any compelling reason why someone in the private sector should be able to use this technology. I cannot see, maybe I don't have sufficient imagination, any compelling reason why the private sector should be able to use that technology.
Thanks very much for that. And I know that members have talked about accountability and responsibility of, for example, a minister to oversee the work of the RCMP. And you have said that that the operational decisions are not made by ministers, and in fact they don't get involved. Can you just perhaps expand on the importance of that division of or that separation of powers and responsibilities?
Well, there's certainly jurisprudence by the Supreme Court on the notion of police independence, which defines the limits of political direction over the work of police forces. If you allow me, at the same time, I've suggested that there could be certain legal prescriptions on the police, for instance, through the Privacy Act. The Criminal Code Part 6 that was referred to frequently has transparency requirements that are imposed by law to the government, therefore including the police. You may want to have a look at these transparency requirements to see whether they should be improved. They're good, but they're probably perfectible.
Thank you very much for that. And I guess my last question to you is around, as part of the motion, there seemed to be insinuation that our CMP is wiretapping or surveilling members of parliament. So, given your very, very great experience with the Privacy Commission and beyond, I wonder if members of parliament, for example, hypothetically, were colluding with others in the planning or the furtherance of illegal activities in Canada, for example, if they were working with the convoy, for example, that occupied Ottawa for a couple of weeks. Would there be any sort of parliamentary privilege that would interfere with the ability to conduct surveillance by the RCMP? And including audits, if a proper court order had been obtained?
All Canadians, no one is above the law. So all Canadians are subject to the law, including the criminal law, and can be the subject of investigations. I think the RCMP stated yesterday that although that might be a possibility, that there are internal mechanisms to ensure that the surveillance of a member of parliament would require higher authorization within the RCMP. I have no knowledge that MPs are surveilled in that way, but certainly at the level of principle, no one is beyond the law.
Thank you very much for that, Mr. Tafian.
That concludes your time. So First of all, I would like to thank both of our witnesses and excuse them at this time. We have some time now to address both committee business, some different pieces of committee business we've got. But before we do that, the analysts have asked to have a couple of minutes to brief me, and so I am going to suspend, but we're going to stay on this call, so we remain in public, and the meeting is still in force, but will be suspended. So with that, meeting suspended.